Feeling like a shark in a shrimp tank. Big fish, small pond in the shrimp tank.
Hey, everybody. Welcome to another episode of the Shrimp Tank. I'm your co-host, Ted Jenkin, here with my co-host, Lee Heisman. Of course, every week, we try to bring you some of the brightest and best CEOs and business owners and entrepreneurs, not only in and around the city of Atlanta, but across the United States. So many people have tuned into the Shrimp Tank the last 8 years because you want to hear the stories of entrepreneurs and learn how to get an MBA in entrepreneurship, a combination of book smarts and street smarts, because you got to have both if you're going to be a successful entrepreneur. As always, if you're tuning into the broadcast, I know we're on video today. You can always get us at podcast at any time on Apple Podcasts, Google Play, Stitcher, SoundCloud, iHeartRadio, Spotify, or anywhere on the internet. I recommend doing that because if you're in the car for 45 minutes a day, you literally can get an MBA in entrepreneurship listening to these shows and our entrepreneurs and what Lee and I discuss with our guests. And you should go onto YouTube, click Shrimp Tank Podcast, click subscribe. That way you get all the videos of all of our entrepreneurs that we've done before, and click that notifications button. That way it comes into your inbox each and every week. Lee, I want to say that we got great guests today, but a lot of people ask us about a lot of things, and especially how to set up a business and how to create this thing and what legal things you have to think about. So we're excited to have on Sharon Tasman today. She is the owner of HTBiz Law, and she knows this, Lee, as well as anybody in the country. So we're excited to get into this discussion today.
I'm really excited to be here. Thank you for having me on. I really, started HTBiz Law to be able to help entrepreneurs grow their business and stay legally protected, and understand that legal doesn't have to be scary. You don't have to hate lawyers, and you don't only have to be a giant corporation to be able to afford good legal advice.
Well, I want to start off and ask you, because I feel like this was accelerating pre-pandemic, but I think it started to accelerate through the pandemic, that I feel like almost everybody I talk to these days has some sort of side hustle. They've got themselves involved into some kind of side business, doing something somewhere. I'm wondering if you can just talk about when's the right time for somebody to set up an LLC when they start that side hustle. Should it be immediate? If they're just making, 10 grand a year, should they not? Is there a thought you have about that?
I do. And actually, given how cost effective it is to start an LLC, which is under typically $300 in every state in the United States, and it's so easy because you can do it with an online form that maybe is 2 screenshots worth of basic, simple questions. I'm a big proponent in that you should start an LLC right away, because the LLC is what separates you from a person and you from a business. And more importantly, it separates your personal assets from your business assets. And just because you're only making $5,000, $10,000, $15,000 that first year, if you got sued as a doing business as your trade name, your personal name only, everything that you've worked up to that point to build is at risk. Even if you've only made 10 or 15,000, you could be sued for 100,000, 500,000, $1 million.
Right.
If you cause damage, and you don't want to put your house, your investments at risk, especially when it's so cheap to start by forming an LLC from the outset. There are additional things you can and should do beyond filing the forms, but for $100 to $300, why wouldn't you at least take that initial step?
Makes sense, Sharon. Absolutely. And, I love you do a speaking piece on this, and you talked about assets and protecting your assets. But an asset that I've always considered to be a detriment, you actually find it to be something that's a positive. And you said age is an asset. I love that. Once Ted and I broke 50, I'm like, well, we're washed up now, well over 50. We're so beyond that. But
So
the way
am I.
you turn it, you look wonderful, or you have a great filter on, but you do something, you look wonderful.
No, I actually have no filter on.
Oh, then there you go.
She told you, Lee.
I know. I'm like,
Sorry.
let me borrow your filter.
I don't filter.
So talk about age being an asset, because a lot of people that start a business are much younger, of course, and even people that are older. We know so many entrepreneurs that waited beyond 40 to start a business, but were concerned if they could do that.
I truly believe that you are never too old and it is never too late. If you think about it, when we're in our 20s and 30s, and nothing against 20s and 30-year-olds, you don't actually know that much. And I was an employee in an other law firm, granted a huge law firm, for 15 years. And then I went to corporate America before I started my practice. So before calling it HTBiz Law, it was the health and technology law firm. But I did a rebrand to make it clear that I did business law as equally as the others. And we only do that. If it's not health, tech, or business, we don't do it. One of the advantages of being over 40 is you know what you know, and more importantly, you know what you don't know. You know at that point what your strengths and weaknesses are, what you can do yourself, where you might want to bring in an expert to help you or somebody to give you guidance. You know pretty quickly, I call it your antenna. Some people might call it a BS meter. It's pretty good at this point, right?
Yeah.
Over 40, And in fact, for women over 40, they start 62% of all businesses owned by women. So it's not too late. And we have skills that we've learned, whether it's the technical skills, it's the interpersonal skills, negotiating skills. All of that comes into play. And I truly believe it makes us better. We understand competition. We've seen what's out there. That's my view.
Well,
I believe age is an asset. I was in my 40s when I started my law firm.
Ask you, Sharon, since you counsel a lot of people that may be over 40 that are starting businesses, there are a lot of people that are in corporate America and they're thinking about making that transition. Do you have business advice for them, legally or not, about making that transition when you're over 40? Because when you're used to the crack of a W-2 that comes from a big employer making hundreds of thousands of dollars, and then you go back to zero, it's not an easy jump.
No, it's not. And it is a mental and emotional preparation as well as a business and legal preparation. You touched on really great points. The first thing I would say is, if you're seriously considering making the leap, have an honest conversation with yourself financially. Can you set aside, I would say, not just 6 months, but a year's worth of assets to cover your lost income? You never know what is going to happen. In all honesty, I ended up not working almost the full year after I started my law firm because my mother got cancer for the 4th time in 3 years. And I was the local child doing caretaking. So I barely worked that first year, which is not ideal when you start your new company. It's not ideal, but I actually had a year's worth of CDs laddered that I could use like income each month. So you want to make sure that you have a replacement source of income set aside. If you've been working, you've been making, well into the 6 figures, you should be able to do this. And if you've waited this long till you're 40 plus to start your business, you don't have to start it tomorrow. Sit down and take a few months to really plan out what that's going to mean, what that's going to look like, because there is a really big shift from employee to employer. You go from having probably an assistant or a secretary. You might have a marketing department. You probably had an accounting department. If you've been in corporate America, you have somebody paying your wages, deducting your taxes, taking care of the payroll of the other people. And all of a sudden, it becomes your responsibility.
Sharon, I wanted to ask you, it's interesting. We're talking about this starting businesses and knowing your expertise, and Lee and I were involved in this every single day because we help people transact businesses. When you're starting a business, a lot of people have ideas about things that they think can change the world. It's a product, a service, something that nobody's ever done before. Number one, should most people work with an attorney to get a non-disclosure agreement, or, Lee and I refer to it as the NDA, every day? So when you're sharing ideas, even with buddies or pals or friends, nobody can technically steal your idea to a degree. And then 2, as you get into it, what are the best ways to protect the intellectual property that you're building? Because it's very easy to get knocked off or ripped off. And my experience is very difficult, if you're not watertight with it, to win in court. It's just not that easy.
So you are 1000% on the right path. And about all of those points. So the first thing I believe is that once you set up an LLC, the next document you need is a non-disclosure agreement. And I believe in having both one-way non-disclosure agreements and mutual non-disclosure agreements.
Yeah.
They're not that expensive to get, quality ones drafted, customized for your business, because depending on the nature of your business, certain provisions need to be tighter or slightly different. If you're in the biotech world, you might need a 10-year or longer confidentiality obligation. If you're a general business consultant, 3 or 5 years may be enough. So there are differences, but you absolutely need to have a non-disclosure agreement, and you need to get it signed before you speak with anybody where you are sharing information that falls into the sort of keys of the kingdom category. Because if you just disclose it to somebody, technically, even with an NDA, someone could steal it, but you have the recourse to stop it. Without an NDA, good luck, right? Even I've been doing this for 30 years. Without an NDA, you really are in trouble. So you always want to be protecting what you are disclosing, even at preliminary conversations. And it can be a friendly document, like I call them client evaluation letters. You do it in a letter form when you're going to a pitch meeting, because for consultants, pitches are often one of your biggest risks of losing your IP. Potential clients say, hey, I've got this problem. Can you give me your approach so I know that you're the right fit? You do it, they have the meeting, and then they go off and keep that and use somebody else. The other thing which you touched on is, how do you protect your content from being stolen? 2 things, both of which are free. Every document, every publication, every website, every page, put a confidentiality notice, a copyright notice on. It's the C in a circle, the year, and the name of your business. Yes, the moment you've actually created something, you become the copyright owner because the rights spring into existence automatically. But by putting that notice on all of the documents, you put the world on notice. So nobody can claim they didn't know it was copyrighted. And the same thing is if you've got information that rises to the next step, your key algorithms, the things that you only share with select partners under a confidentiality agreement, you still want to put confidential information of your company name every time. And of course, we're dating ourselves. You know how when books used to be the most popular thing, you gave somebody a book, not a PDF. When it was physical books, and yeah, I still love books. I have books. When you gave somebody a physical book, you only needed one copyright notice, and it's typically on the inside of the front cover. But now everything is shared by PDF or other electronic means. I truly believe, and if you look at any of my downloadable roadmaps or handbooks, every page, every footer, every time, copyright, the year, my name. And I even, for my videos on my social media channel, have a combination copyright notice and disclaimer at the end of every video, because it can be hard to get somebody to take down infringing work where somebody has just stolen what you've done. And I've seen people copy word for word, say it, repeat it. But if you can go, hey, Instagram, Twitter, Facebook, here's the original, here's the date I posted it, and here's the copyright notice that was part of it, it's going to make it much easier to prove that the other person stole it. And also having the habit, the pattern and practice, oh God, I sound like a lawyer, the pattern and practice of always doing it goes a long way. Because if you did have to go to court, it's great to be able to say, I always do it. Look, there's no way I didn't. They can't claim they didn't know. I claimed my rights.
Yeah, and you have this experience, which is quite amazing. And Sharon, I love the name of your roadmap. Actually, Ted, Ted and I have a television show called The Roadmap on channel ASBN, and that actually just got launched across Roku, Apple TV. 70 million different eyes have access to this now. But it's the roadmap, Sharon, of how people grow, start, and ultimately exit a business, which is intriguing. And you actually have one called the Legal Essentials Roadmap. And what I want you to talk about a little bit is 2 pieces out of that. Number one is your digital assets, how to protect them. I think that's really important for our viewers. And then number 2,
your cryptocurrency?
Exactly.
No, not cryptocurrency.
We don't-
Your copyrights, your trademarks, your algorithms, all of those
And if
things.
you had any crypto, Ted, it's not worth protecting anyway right
That's
now.
true.
It's worth
Right now,
nothing.
no.
But and in addition, could you second that with, I love this little piece you speak of, staying out of trouble on the internet. So start with how to protect your digital assets, and then how do you stay out of trouble on the internet?
So the first step to protect your digital assets is to know what they are. So many people don't realize all the things they own. So effectively, what you want to do is your own digital asset audit, self-assessment, pick whatever word scares you less. But you want to sit down and figure out all the things you have. And you need to figure out if you actually own them. Because copyright law, which covers reports, drawings, software, computer code, publications, is a little bit counterintuitive. If I hired you, Ted, to create something for me, but you and I were friends and we did it just on a handshake, even if I paid you $1 million, you own it at the end of the day and not me. And this comes up all the time in the tech world, because under copyright law, the person who creates it is the owner of all the rights, unless they affirmatively, in writing, give away some or all of those rights through an assignment or a license. So if you and I were friends, we did it on a handshake, you own the work. And then, a year from now, 2 years from now, when Instagram or Facebook comes knocking and they want to buy it from us, guess who's going to get paid a lot of money to retroactively assign that IP to me? You are. And this catches companies that are big and know better. So if you are small, a startup, and you just realize hearing this, don't worry, it happens to everybody, and we can fix it, preferably before a venture capitalist comes in and wants to invest a lot of money, because they send in someone like me. For 10 years, I worked with VCs where I would be the one who would go in and dig to figure out, think about it. Microsoft started in a garage. Apple started in a garage. Now, Bill Gates probably had an agreement with his friends because his dad was a lawyer, but most garage kind of startups don't, and it does come back to bite them. So you need to figure out what algorithms, tools, reports, all those things that make you special, that give you an advantage over your competitors. You need to make sure they're locked up. Figure out what they are. Figure out, did you develop them? Did, I hope not, develop them while you worked for somebody else? Or did somebody help you? And you need to lock that up now, before you blow up and become a massive success. Now is the time to do it. And believe it or not, in many instances, we can do it in one page. It's called a nunc-pro-tunc retroactive assignment. We do them all the time.
Most entrepreneurs, when they get rolling, they're eventually going to bring employees in their business. And I'm just wondering today, because I think Lee and I have seen a whole different number of versions around this. Well, one, do you want to get an employment contract for employees in your business? And then two, how tight are these non-competes and non-solicits today? I feel like more and more that some states seem to be at will, and it gets harder to enforce these things, and the radius and the ranges. Any advice for those entrepreneurs starting to hire employees?
Yeah. So the first question is, you need to make sure that you're actually looking to hire a true W-2 employee versus someone who might be an independent contractor. That's the first step. Is this someone who's helping you a few hours a week using their equipment? You're giving them general guidelines. They're probably an independent contractor. Are they working for you full-time? Are they, you really control what they do? Are they using your equipment, your location? More likely an employee. So that's the first question, contractor and employee. If it's an independent contractor, that independent contractor agreement needs to have very tight intellectual property, or IP, assignment language, which covers trademark, copyright, patent, trade secret, any other IP that they may create. So in an independent contractor scenario, a well-drafted independent contractor agreement covers that issue. When it comes to employees, you might want to have somebody as an at-will employee, but that doesn't mean you can't have an employee assignment of inventions agreement. This happens all the time in the tech world. Even if you don't have an employment contract, you still can be asked to sign something that gives your rights and your developments to the company. It will often include the right for you to carve out things you created before your job. But be very careful, because if you don't carve them out, they will move to the company. So Some rights will move automatically by operation of law, like copyright, but things like patent don't typically. So if you have an employee that's going to be in a creative role, I would get an assignment of inventions or an employee assignment agreement, whether or not you have an employment contract. When it comes to non-competes and non-solicitations, the trend is definitely downward because courts generally, especially if you're in California and several other tech-friendly states, they don't want to restrain the ability of someone to work because especially now where jobs are coming and going, the economy's tighter, we're coming out of the pandemic, it's been 3 long years, people have to work. And courts do not like to enforce overly onerous non-compete agreements. So they have to be reasonable as to geographic scope and duration and like the field of limitations. So, and it also needs to be rationally tied to how valuable that person's knowledge is. So to tie up a janitor for 3 years because, well, maybe they saw something, it's never going to fly. But if you have your chief technology officer, you more likely are going to be able to have a reasonable limitation on them. For example, 6 months to a year, only in your field, can't go to a direct competitor. And even without a non-compete, if you had an assignment agreement or any confidentiality agreement with the employee or contractor, they can't use it legally anyway. So all you're really preventing, honestly, with a non-compete is the information that resides in their head, sort of that general knowledge, or maybe the general industry skills. Because even without it, stealing confidential information is stealing confidential information.
So Sharon, let me ask you an important question. You know, lawyers, like accountants, they usually charge by the hour. And what would your recommendation be for people out there looking for counsel like yourself? If they're obviously, we want them to contact you, no question, but if they do have counsel currently, how do they avoid working with somebody that, and I say this with the utmost respect to lawyers, if they're not efficient, they're making more money, right? So the longer counsel or legal provide and take to do a particular task, the more money they make. It's almost counterintuitive, but also beneficial for someone to be real slow versus really efficient. What would you say to that?
So what I would say is the first thing is if a lawyer is not willing to have at least a 30-minute initial consult with you off the clock so you can see that you're a good fit, run, right? You need to understand that they're going to be a part of your team and you have to have a good working relationship with them. I mean, it may be part of my job to be the professional bad guy so the client doesn't have to say no to the other side. They lay it on me. You know, I would love to do it, but my lawyer says I can't. I still want to have a great relationship with my potential client. And it could mutually be a bad fit in one direction or the other. The second thing is lawyers who've been doing this a while, we know about how long it takes. A lawyer should also be willing to give you an estimate of how long a particular type of project will take, especially if it's something that's more common. Now, if you're saying, I need you to negotiate this one-of-a-kind, unique thing that's no one ever done before, or something really massive like a nuclear power plant, and I've done that, you can't really give an estimate on that. But it's also when it comes to small and startups, I don't know about other firms, but for example, I have honestly a 2-tiered rate system. For startups, I give a discount for solo and small business. And I also, because I've been doing this 30 years, I know how long certain things take me. So I've created flat fee packages so people know exactly upfront what it will cost and exactly what they're going to get. It's going to include an initial consultation. I get all the information I need. I draft the documents that are part of the package. I then give them, rounds of revisions in case they have questions. And then when the documents are final, included in my packages is an hour where I'll sit down and go over with you what these are so that you can use them without me in the future. It is counterintuitive. In a way, I'm trying to write myself out of a job. If I've drafted your MNDA for you, mutual non-disclosure agreement, all you should have to do is change the name of the other person you're talking to and the subject you're talking about and why you're talking about it. If I've done a good job drafting your client agreement or your services agreement, I've set it up so that the only thing that has to change is your description of services. And I'll show you how to do it yourself, so you don't have to come back to me unless you want to. Do you want me to negotiate it for you, or do you want to do it yourself? But you're going to have the documents and you're going to know what it cost upfront. So those are the things. Ask the questions, have a consult, figure out whether they'll do anything on a flat fee basis.
So one final lightning round question here, and then we want to tell our listeners where they can get your expert legal advice. What's the worst state to set up a company, in your opinion?
Oh, I really don't want to answer that.
What's the best state to set up a business, in your opinion?
If you are going to be a small business, not a mega corporation, set up in the state you live in. So that way, if you need to go to court, you're going to the court in the state where they know their own laws. If you get really, really big, then you consider places like Delaware or New York. But initially, as a small business, pick the state you're in.
Well, I tell you, this is great advice. There's so many people out there that I believe that a lot of owners, they skimp on legal fees when they start their business, and it ends up costing them more down the road. So all of our listeners, look, you've got to get a good attorney or a sleeve of attorneys on your side. It really helps you with your business. Sharon, for our listeners today and our viewers today, how can they get in touch with you and learn more about your company?
So you can find me on the web at www.HTBiz Law, like healthtechbusinesslaw.com. And on Facebook, Instagram, YouTube, TikTok, we are at HTBiz Law. We try to keep it simple. And if you're looking to get my legal essentials roadmap, it's roadmap.htbizlaw.com. I try to keep it simple.
Let me tell you something, guys. I could sit and talk to Sharon for 2 hours. We could make this a 2-hour podcast. We could do a seminar for 2 hours, just asking you questions and bringing CEOs. You know, Ted, now that I think about it, that might not be a bad idea.
I'll come back. Happy to come back.
No, that's actually, we could do something like that, because her knowledge base and the way that she shares that information is wonderful. I like that you said keeping it simple, but I would like for you to say 3 times in a row, as fast as you can, as we wrap this up, nunc-pro-tunc retroactive assignment. You said that earlier. Is that right?
Nunc-pro-tunc retroactive assignment. Nunc-pro-tunc retroactive assignment.
Okay. Beetlejuice is coming out, Ted. I'm telling you, you said it 3 times. I just wanted to hear nunc-pro-tunc retroactive assignment, because Ted, she threw that one out there earlier. I took a note of it. I'm making a t-shirt. Sharon, that was amazing. Thank you so much for coming on the show today, guys. And that was our episode of The Shrimp Tank.
I've been feeling like a shark in a shrimp tank. Big fish, small pond in the shrimp tank.